Hello friends. Today we're going to discuss about Supreme Court's decisions with regard to human rights of persons with mental illness. In simple words, judicial interventions to uphold the human rights of persons with mental illness. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about human rights violations of persons with mental illness. What are those important judicial interventions with regard to human rights of persons with mental illness? Human rights violations can be understood in simple cases. I'll be discussing an important case which occurred in India. A 77-year-old man said this: I don't know why I was arrested, nor do I remember the date when I was arrested. It has been so many years. I was young when I was arrested. These are the words of Machal Lalung. This is a case of a writ petition which was filed in Supreme Court. Mr. Machal Lalung was 23 years old in 1951. As soon as we got independence, he was working as a laborer. On one fine day in 1951, he had an acute psychotic breakdown. He injured his fellow colleagues. It was a simple injury. Unfortunately, he was arrested. Since he had mental illness, he was taken to Guwahati prison, from there to Tejpur Mental Hospital. For him now, after the arrest in 1951, the time is frozen. From 1951, he has not seen the light outside the prison. On 2005, he was released on the intervention of Supreme Court. That is, after 54 years, he was released. And he was there as under trial for so many years, my dear friends. He was kept in the Tejpur Mental Hospital for 26 years. And when he became all right, he was found to be fit to stand trial. He was sent to Guwahati prison. He was kept in the Guwahati prison for 28 years. He spent 54 years as under trial in judicial custody. And because of the Supreme Court intervention, he was released at the age of 77 years. This is the plight of persons with mental illness if he is arrested and he is put in the prison. Now, let's understand non-criminally mentally ill. What does it mean? Let's discuss about this. The biological treatment, that is medications, electroconvulsive therapies, various came only after 1930s. That means before 1930 there were no treatment available. After 1930, various psychopharmacological agents and various electroconvulsive therapies and other biological treatments came into picture. Till then, custodial care was the only option to provide care for the person with mental illness. But here, it was not for caring. It was a custodial care so that he is isolated to keep him away from the community. It was here the people used to think this dangerously mentally ill should be kept away from the community. That means public safety was taken more importance. Hence, if you look at the various mental health legislation, they were custodial in care. If you look at the Indian Lunacy Act, it clearly spoke public safety is more important. Hence, he has to be shifted to Asylum. In this regard, if you look at the history in India, earlier mental hospitals were managed by prison department. The reason being it is custodial care only. Inside the prison, one part of the prison will be for the criminals and the other part was for mentally ill. That means non-criminal mentally ill person were determined. Only in 1905, the prison which housed persons with mental illness was handed over to the health department. Till then, it was custodial care, hence, the prison department used to look after them. Only in 1930, the biological treatment came in. And then the paradigm shift occurred from custodial care, focusing on treatment aspect. In this regard, there are various PIL has been filed in the Supreme Court and various high courts to release these non-criminally mentally ill persons inside the prison. If you look at the evolution of Mental Health Care Act, Indian Lunacy Act 1912, before that it was more of custodial care. No treatment was given. It was isolated from the community so that the public and the community are protected and the dangerous person with mental illness is kept in the prison. With the Mental Health Act of 1987, there were new various treatments available with regard to medication, electroconvulsive therapy. Hence, this law focused more on treatment aspects. And finally, the paradigm shift occurred with the rights-based approach with regard to provision of Mental Health Care Act and protecting the human rights of a person with mental illness during the provision of services. That is, my dear friends, Mental Health Care Act of 2017 was enacted. Now let's look into the apex court's decision with regard to non-criminal mentally ill person inside the prison. The first case I would like to discuss is Veena Sethi versus State of Bihar. On 15 January 1982, the Free Legal Aid Committee of Hazaribagh to the Supreme Court, which set a judicial process in motion. This motion was, the letter drew the attention of the court that atrociously illegal detention of certain prisoners in the Hazaribagh Central Jail, Bihar, for almost 2 to 3 decades were presented. And this was considered into a PIL. Many non-criminally mentally ill, they are there for almost 3 decades without any judicial intervention or else any kind of hearing of those people. Not even treatment was given. They were detained without any justification whatsoever. These forgotten specimens of humanity languishing in jail for years behind the stone walls and iron bars, deprived of freedom and liberty, which are the inalienable rights of human beings, would have been continued to remain in jail without any hope for ever walking out of this forbidden environment and breathing the fresh air of freedom. This is the words of Supreme Court. These prisoners were lost in the oblivion of time and had become merely a ticket number in the Hazaribagh Central Jail, although they could cry in despair without any hope. And in this, the Supreme Court said that the state government will provide the necessary medical treatment of these prisoners and make arrangements for these non-criminally mentally ill to be released into the community. Apex Court directed the state government, in the case of these prisoners, to submit half-yearly report about their mental condition by the superintendent of this prison to the state government health department on periodic basis, that is every 6 months once. Immediately in 1986, there was another landmark Sheila Barse versus Union of India case was filed. Again in this case, an important journalist who took a note about non-criminal mentally ill people were detained in the jails of West Bengal. By looking at this article, the Supreme Court considered it as a PIL, and it clearly held that the detention of a non-criminal mentally ill person in a jail is illegal and unconstitutional in the eyes of the law. That means you are not supposed to arrest a non-criminally mentally ill person. Unfortunately, Indian Lunacy Act continued to exist even in 1986. My dear friends, this is the plight of the persons with mental illness across the globe. It is not just only in India. Name the country where human rights violation of persons with mental illness occurs every minute, every hour, every day. Hence, in this year, World Mental Health Day celebration on October 10th, World Health Organization has given a theme. Mental health is a universal human rights. Our minds, our rights. This is the apt theme. Every country observes this World Mental Health Day on 10th of October to make aware about the rights of persons with mental illness, to remove stigma and discrimination, to urge the policymakers, politicians, executives, healthcare workers, and also public at large regarding mental illness and also the families who are facing the brunt of persons with mental illness burden. Now let's discuss about the inhuman conditions of mental hospitals which were reported to Supreme Court. The first and the foremost case is Chandan Kumar Banek versus State of West Bengal. This case was filed in 1990. A PIL, that means a public interest litigation, was addressed to the apex court based on the basis of a press publication with a photograph showing a mentally ill person was chained in the hospital. Immediately, Supreme Court took this as a PIL. A notice was issued to the state government of West Bengal. A committee was formed and an inspection was made into the mental hospital, and a report was submitted, and it clearly highlighted the inhuman conditions in this hospital. Again, apex court said that management of institution like the mental hospital requires flow of human love and affection, understanding and consideration for mentally ill persons. These aspects are far more important than a routinized, stereotyped, and bureaucratic approach to the mental health issues. And apex court said, make improvement in these hospitals. Of course, West Bengal, as you know, made only courtesy changes into this. Within few years, again, one more important case came in front of Supreme Court, that is Chandrakumar Podar versus State of West Bengal. Again, in this case, the Supreme Court ordered to eliminate inhuman activities like use of iron chain to physically restrain the patient by the hospital staff at the mental hospital at Manakundi Hooghly hospitals. And they ordered to stop inhuman activities. This is mental hospitals at West Bengal, my dear friends. Similarly, another important case, which is Rakesh Chandranarayan versus State of Bihar. This is with regard to Manasik Arogya Shala of Ranchi. Earlier, Ranchi was in Bihar, and hence this case cites as Government of Bihar. Again, this is a petitioner wrote a letter with regard to inhuman condition of Manasik Arogya Shala. The court treated this as a public interlitigations under Article 32 of the Constitution of India. And the apex court directed the Chief Judicial Magistrate of Ranchi to visit the hospital and submit a report regarding the prevailing condition of this mental hospital. The Judicial Magistrate reported there is a severe shortage of water, electricity, beds, medicine, and medical personnel. Sanitation and hygiene was also a recurring problem for the inmates inside the mental hospital. But, as you know, the state government denied all these claims with regard to the report. Subsequently, in 1994, the Union Health Secretary M.S. Dayal visited the hospital and formed a report which is called as Dayal's report on the functioning of the hospital. And also he gave a recommendation which is called as Dayal's recommendation. The court held that it was essential that the hospital remains an autonomous entity to ensure its smooth functioning, and also approved Ranchi Mansik Arogyashala Rules 1994, which was recommended by Dayal report. And now that institute has become RINPAS, my dear friends. Similarly, another important case, B.R. Kapoor versus Union of India in 1990, a case which came in front of the apex court with regard to Shadram Mental Hospital of Delhi. A writ petition under Article 32 of the Constitution of India was registered by a way of PIL with relating to mismanagement of the hospital of mentally ill. Immediately, apex court took notice of that. A committee of experts consisting of 4 psychiatrists was formed, and they were asked to look into the mismanagement of the hospital, condition of the persons with mental illness, and what are the recommendations to be done. This committee gave a 35 specific suggestions with regard to Shadra mental hospitals. The Supreme Court instructed the New Delhi administration to take immediate steps to provide adequate funding and set up a mental hospital into a training institution or a college with sufficient autonomy to bring about quality changes in the patient care. If the government of Delhi is unable to do it, the Supreme Court categorically said that to shift this state-based mental hospital under the central government, and the central government should look after this. But however, the government of Delhi made drastic changes. Good amount of funding was started, and it was named as the Institute of Human Behavior and Allied Sciences, that is IBAS, my dear friends. Now, one of the best hospital which is available in North India. Similarly, another important case with regard to Gwalior Mental Hospital came into picture. Supreme Court, Legal Aid Committee versus State of Madhya Pradesh. Again, in this case, the Supreme Court ordered the state of Madhya Pradesh to improve the condition and functioning of Gwalior mental hospitals, and also asked to provide better facilities for the inpatients. Further, a series of PIL were filed, and one of them notably is Dr. Upendra Bakshi versus State of UP. This can be traced as his first PIL with regard to persons with mental illness or mental retardation and their inhuman conditions where they are lost. This is concerned with the inhuman treatment of inmates in a protection home of Agra. And when these inmates were examined, 33 inmates had mental retardation along with behavioral problems. And this Upendra Bakshi versus State of UP gave various recommendations, various orders were done, and also made efforts to change various protection homes, and also shifted mentally ill person from these homes to the mental hospitals of Agra and various places. In the same cases, National Human Rights Commission was entrusted for the supervision of these 3 major hospitals: Ranchi Mental Hospitals, that is RINPAS, Agra Mental Hospital, and Gwalior Mental Hospital. The National Human Rights Commission started monitoring these hospitals. Further, along with the Supreme Court and National Human Rights Commission, clearly said and asked NIMHANS to carry out the project called as Quality Assurance on Mental Health Care in India. In this, the NIMHANS Bangalore did survey of all the mental hospitals, visited them, interviewed patient, looked into the infrastructure, rights of persons with mental illness, how the patients were admitted, whether they are following Mental Health Act of 1987 or not, whether the board of visitors were there or not, how the food was given, whether the patient received medicine or not. And an important publication came into picture, that is Quality Assurance on Mental Health. And from there onwards, mental hospital starts improving under the National Human Rights Commission's direction. This is with regard to mental hospitals. However, you need to understand more than mental hospitals, patients are treated in religious institutions. It may be temple, it may be dargah, or maybe even church. Here also, persons with mental illness are treated in inhuman conditions. Let's look into one of the important case which you need to understand and learn how persons with mental illness are treated. A petition was received in August 1998 alleging that persons with mental illness were being kept in chains and confined to a space where it was difficult to move around in Sultana Alayuddin Dargah at Gauripalyam near Madurai. Looking at this report, the Supreme Court ordered the district collector to visit these places and to submit the report. Of course, the collector went to this place and confirmed that 92 mentally ill persons were staying in the dargah, having been brought by their relatives who had faith in the curative power of dargah. The collector, however, denied the mistreatment of persons with mental illness in these places. However, further Supreme Court was not satisfied. If there are 92 people in this dargah, how they are taken care? Hence, the second inquiry was done. Director General of Prisons was requested to go and do the visit. He did the report, and under his report, he said 500 patients and devotees are staying inside the campus of dargah. 3/4 of them are Hindus, and remaining belong to Muslim and Christian. About 100 patients were found to be chained inside the dargah. Patients were kept in a thatched shed in verandas. The report highlighted that similar places and dargahs existed in and around the Tamil Nadu and in various rural areas. And the persons with mental illness plights was very poor was highlighted in this report, and also he highlighted that faith-based treatment was very high because of ignorance and also because of stigma. The state government did not accept that report. Hence, one more committee was formed under the chairman of Dr. K.S. Mani from Bangalore. Again, he visited these places, did the inspection, and submitted the report. He highlighted very important things. He said that in his report, responsibility for admission and discharge must be in the hands of qualified psychiatrists, not based on the faith healers. There should be a strict supervision with regard to administration of medicine. Institutionalization should be only for brief. Patients should not be kept for longer duration in these dargahs. Family members should not be allowed to dump these patients in dargah. They need to stay with the patients in the dargah during the treatment. The living conditions of the dargah needs to be improved, without which the rights of the persons with mental illness will be violated. There should be facilities for early diagnosis and regular treatment of mental illness in the areas of religious places like dargah, temple, and church. On January 2001, the K.S. Mani's report was accepted by the Supreme Court, and then that report was sent to Tamil Nadu government for its compliance. Tamil Nadu government was in the process of going through the report, and in the same year, in August 2001, unfortunate Erwadi incident occurred. Let's discuss about Erwadi fire tragedy which occurred in 2001. This is again a famous dargah. Qutubus Sultan Ayed Ibrahim Sahed from the Saudi Arabia who came to India for propagating Islam. Many people believed that he is one of the saint, and because of worshipping him, many mental illness can be cured. It is not only Muslims, Hindus and Christians also believed this. And people believed that holy water from this dargah and oil from the lamp burning there can hear and heal and cure many mental illness. Here the treatment included caning, baiting, chaining the patients to drive away the evil spirit which is there in a person with mental illness. During the day, the patients were tied to the trees with thick ropes. At night, they were tied to the beds with iron chains. Unfortunately, on 6th of August 2001, 28 inmates who were chained to the beds, to the trees, were caught in the fire. All these 28 inmates were bound to this bed and the tree were charred to death, my dear friends. This was the biggest tragedy with regard to human rights of persons with mental illness. This is the photograph of the charred bodies of persons with mental illness. Immediately, the Apex Court took note of this. Quality Assurance, which was released in 1998 by the Nimans, Bangalore, was brought into picture. Immediately, committees were formed across the country, and every state were supposed to implement Mental Health Act of 1987. State mental authority were supposed to be formed. Registration of all these places where mentally ill patients were kept were supposed to be registered, and they were asked to do compliance with certain important agendas. That is, formation of state mental authority, formation of state rules with regard to Mental Health Act of 1987, whether the Mental Health Act of 1987 was formed or not, whether state mental authorities were doing meetings or not, whether the hospitals and the places where persons with mental illness are kept were registered or not. And then onwards, a slow improvement started occurring in South India. Let's discuss about the recent Apex Court's decision with regard to persons with mental illness and human rights violation. In this notable is Gaurav Kumar Bansal versus State of UP. Here, one of the human rights activist advocate filed a PIL in the Supreme Court with regard to keeping of cured patient or recovered patient in mentally ill hospitals for longer duration, that may be from 2 to 3 decades, my dear friends. In this PIL, he requested the Apex Court to give order to the states to release these recovered, cured mentally ill from the mental asylums. And also is requested for setting up rehabilitation home for persons with living mentally ill who have been cured or who do not need further hospitalization inside the asylum, or who are homeless, or who are not accepted by the families. These are the people we need to be rehabilitated. And he requested the Apex Court to direct all the state governments, especially the Social Welfare Department, to make arrangements with regard to rehabilitation of these persons with mental illness. In this regard, two important guidelines were framed. The first guideline is Guidelines for Discharge of Mentally Ill Cured or Fit to Discharge Patients from the Mental Health Institution. And this was framed by Ministry of Health and Family Welfare. This was distributed across the state, and all the mental hospitals who met the criteria for cured mentally ill were supposed to be discharged, and they were to be taken care by the Social Welfare Department. That's where the second guideline comes into picture. The guidelines for the state government for setting up of rehabilitation homes for persons with mental illness, framed by the Department of Empowerment of Persons with Disabilities, so that the deinstitutionalization process leads to placement of persons with mental illness in the community. These guidelines were laid down, and these models were supposed to be followed by the state government for discharging the recovered patient, also setting up of halfway homes, long stay homes for deinstitutionalized patients. The government of India also framed Deen Dayal Disabled Rehabilitation Scheme. These are the revised guidelines for deinstitutionalized persons with mental illness on 1st of April 2018. Under this scheme, halfway homes were supposed to be set up, occasional rehabilitation for persons with mental illness to be done, ensuring the continuity for access to healthcare to be established, reintegration of persons with mental illness with their families and communities at large was envisioned. Gaurav Kumar Bansal also has filed various PIL in the interest of persons with mental illness. During COVID, he requested the Apex Court to give direction to various state governments with regard to testing of COVID for homeless persons with mental illness because they do not have Aadhaar card. Nobody is there for them even to test COVID. Further, they also needed COVID vaccine. And again, you require Aadhaar card for them. The Supreme Court immediately acted and gave instruction to all the institutions and the state governments to do the COVID testing in persons with mental illness who are homeless and who are also institutionalized. Further, he also made a PIL with regard to non-compliance with regard to health insurance for persons with mental illness. Many insurance companies refuse to provide health insurance for mental illness. Again, Apex Court came into rescue of persons with mental illness. Further, he also approached Supreme Court with regard to persons with mental illness were not allowed to pursue MBBS education. And this is still pending in the Apex Court, waiting for the judgment from the Apex Court. Human rights and mental illness, they are bidirectional in nature. What does it mean? If there is a violation of human rights, that person may become mentally ill. If a person is mentally ill, his rights are violated easily. Let me give you in simple words. If a person is arrested without any reason and he is put behind bars without any hearing by the court, inside the prison he may become mentally ill. On the other hand, a person with mental illness is wandering at large. His rights can be violated by the public at large or even the government. People can abuse him. That means human rights and mental illness are in bidirectional. We need to break this complex jinx so that human rights of persons with mental illness can be upheld. If you have a good respect to human rights, there will be a better health system and better mental health. To conclude, my dear friends, persons with mental illness are vulnerable population for human rights violation. At the same time, human rights violation can push a person for mental illness such as depression. In spite of Constitution of India, various laws, unfortunately, promotion, prevention and protection of human rights of persons with mental illness has not occurred in India. Still, the human rights for persons with mental illness is distant and dream far from reality. In this regard, National Human Rights came and played an important role as a promoter, facilitator, and a catalytic agent, and also as a watchdog, but it cannot implement. In this regard, judiciary and the Supreme Court became the savior for the persons with mental illness, protecting, promoting, and also upholding the rights of persons with mental illness. It is the politicians, executives, and the society at large has to act to protect the persons of mental illness, their rights. We need to implement Mental Health Care Act of 2017 so that rights of persons with mental illness and right to access for mental health care becomes reality in India. And apt, my dear friend, this year theme, mental health is a universal human right. Our minds, our rights. Thank you for giving your valuable time. Stay safe